Good morning, everybody. I'm Jesse Weber, and welcome back to Law and Crime Live. This is where we cover some of the most interesting live trials in the nation today. And we're also very happy to be broadcasting to you live on the Crime and Investigation Network. Thank you so much for joining us. So let's talk about what our live trial will be for today. We are entering into day 13, ladies and gentlemen, into the Claude Tex McIver case out of Atlanta, Georgia. We expect it to begin again at 9:30 a.m. Court is a bit delayed today. There needs to be a conference between the attorneys and the judge in this case. This is the one that we've been following all week. It is the one about a prominent local attorney who is charged with the murder of his wife, Diane McIver, by shooting her from the back seat of a moving car. That's right, you heard it right. But the defense is saying this was all a tragic accident, that the gun went off by accident, that this was not an intentional shooting. Now, this week has been very interesting. We've delved into the financial motive of this case. The prosecution is saying that Tex McIver shot his wife for financial gain, for financial reasons. We looked at Diane McIver's will. Yesterday, testimony delved into the deteriorating financial position of Tex McIver at the time of the shooting. We also saw yesterday all of Tex McIver's guns were on display for the jury. And that's also interesting because we saw an interview yesterday in court that Tex McIver provided to a media outlet where he said, guns aren't really my thing. But you see it yourself. Look at all the guns that he had. Now, we keep talking so much in this case about the murder charge, but we can't forget that Mr. McIver is charged with multiple crimes, including 3 counts of influencing witnesses. That's right. The prosecution believes that he engaged in witness tampering, trying to cover up what he did. We have a short recap explaining those charges. Take a look.
Attorney Tex McIver says a gun he was holding discharged accidentally. The bullet struck and killed his wife, Diane. The state is trying him for murder and witness tampering. Danny Jo Carter was driving the car when the gun went off. She says the defendant asked her to tell a different story after they rushed Diane McIver into the emergency room.
Anything else?
You just need to say you came down here as a friend of the family. I said, Tex, I just drove you into the emergency room.
And then did he say something in response to that?
He looked at me and he says, well, they don't know that. Well, that took my breath away.
Also in the emergency room, nurses said the defendant told different versions of how the shooting happened.
I heard him say, and this is what I heard, and it was in passing. I was passing through that I was cleaning my gun in the bathroom and I shot her.
I'm sorry.
I was cleaning my gun in the bathroom and I shot her.
And you heard him say that?
Yes, from him, not from anybody else.
He said to me, it was an accident. I had the gun in the back seat and it just went off and it was an accident.
Nurse after nurse testified about hearing the defendant's bizarre statements and behaviors.
The first words that I vividly remember was the tell them, and then it was like a softer, this is what you're going to tell them, as I was like walking past.
Okay.
So it was like more of a conversation that I was hearing, not like just a one-shot term.
Did you linger such that you could hear?
No, I asked Alicia Redding to position herself that she could further evaluate if I had heard correctly.
Okay. And do you know whether or not she actually did that?
I believe that she did.
Did you tell Alicia to contact the police?
I told her that she needed to speak with the police if, in fact, she heard anything.
That same nurse admitted there was a lot of gossip in the ER.
And some of the nurses in the ER, some of the techs, the people you were talking with, that you heard, were saying, he's going to get off because he has money.
That is correct.
That's what the nurses were saying. Just like OJ got off because he had money.
That is what was said by one of the techs.
Defense attorneys used that and other tidbits to attack the credibility of the nurses. But it still doesn't explain away that Danny Jo Carter felt pressured to lie. This is Aaron Keller for the Law and Crime Network.
As we wait for the live feed in this case to continue, let's break down these influencing witnesses charges. And joining me on set to help explain this is criminal defense attorney Yosha Gunasekera. Yosha, great to see you.
It's great to be here.
Yosha, I'm not a smart man, so I need you to help me break this down. Okay, we first heard the Danny Jo Carter one. So the charge there is Tex said to her, Danny Jo, don't get involved in this. Don't even tell them that you were driving the car. Is that an influencing a witness charge? Would he be found guilty of that?
Well, the key is whether he's asking her to speak untruthfully in an official investigation. So,
isn't that what he did?
Well, I think the defense attorney is trying to spin it as he's just acting stupid. In fact, I believe that's what the defense attorney said at one point. This is just a man who is scared. He's freaking out. He knows that he is an attorney, and he's just in a moment of panic. Whether he's really asking her to testify untruthfully to the police.
Does it matter what she thought? Did she feel pressured to lie? Is that the standard?
Well, I think that that's definitely going to come into play. It's both going to be what Tex is asking of her and what she actually thought. Did she think he was joking? Did she think that he was acting seriously? Because if she didn't think that he was acting seriously, then maybe they can't make out. He faces
two more charges of influencing witnesses, including telling Tom Carter, Danny Jo's husband, delete that cell phone message I left and he said, Danny's about to send me to prison. Delete this message. It's innocent, but it's nuclear for me. Is that influencing a witness charge?
So,
is that guilty of that?
Destruction of evidence to impair with the intent to impair an investigation is certainly trying to influence a witness. But the question is, did he have the intent to actually impair the investigation? And obviously his defense attorney is going to say that he didn't have the intent.
How do you show he didn't have intent by saying delete the message?
Well, he's just going to say this was just a private conversation. It really had nothing to do with the actual case itself. It's just personal communication. Feels like a stretch at this point, so it's going to be very interesting to see what the defense turns up.
Final charge that he had for influencing witnesses. We haven't heard this yet in the case, and we only have about 30 seconds, so we have to talk about this real quick. Bill Crane was his PR specialist. First wanted him to talk about the Black Lives Matter movement. Then he told him to retract that statement. It seems like he's giving him misleading information.
It might not exactly be witness tampering, but it doesn't look good for Tex because he's constantly changing his story, and it's frequently why criminal defense attorneys tell their clients not to speak to the press without them present, not to talk about the case after it's happened at all. And so that was a mistake here.
What it sounds like to me, Yosha, is that it's not an open and shut case for the murder charges, and it's not an open and shut case either for the influencing witness charges. And that's really the best part about this case. It can go both ways. So we are going to take a quick break, and when we come back, we have a lot to discuss in this case. Welcome back to Law and Crime Live, everybody. We are waiting for our live feed in the Tex McIver case out of Atlanta, a prominent attorney who's on trial for the murder of his wife, Diane McIver, by shooting her from the back seat of a moving car. But he says he didn't shoot her intentionally, that it was all a tragic accident. But he's not only charged with murder, he's also charged with 3 counts of influencing witnesses. And we don't really talk about those charges so much yet, and I think we should. And we talked about before the break, he is charged with 3 counts, and one of them is telling the driver of the car, Danny Jo Carter, don't get involved, don't tell the police that you were driving the car. And we debated back and forth about whether or not that was an influencing witness charge. But we also talked about the fact that Claude McIver told Tom Carter, which is Danny Jo's husband, Danny Jo's going to get me in a lot of trouble. Delete this message. I want you to play for you right now in court when that was played, and you be the judge for yourself. Is this a witness tampering, influencing witness charge? Let's listen.
Tommy Lee is Tex. Sir, let me just be plain. Danny is about to send me to prison. Please erase this voicemail message, but call me right away. Y'all have no idea the problem this is causing. It's innocent, but it's absolutely nuclear for me. Please call me.
All right. Again, I'm here with criminal defense attorney Yosha Gunasekera. Yosha, we talked about it before the break. That sounds a little bit like trying to get somebody to not be forthcoming with the police and to try to cover up evidence.
Sure, but there has to be a little bit more here. His defense attorneys are going to argue there's no threats, there's no use of physical force, and really the statute is saying that he has to be purposefully misleading in trying to get them to not speak to the police or trying to get them to destroy that voicemail. And I think that he's being very clear. So I think the defense attorney is really going to rely on a very literal reading of the Florida statute.
Let me ask you this, okay? Is it possible, because we talk about so much in this case, the murder charges can be a bit flimsy here. I think everybody agrees that he was very reckless. Do you see a situation where he might not be found guilty of murder, maybe found guilty of a lesser charge, but will definitely be found guilty of the influencing witnesses charges?
It's certainly possible that he could be found guilty of that, but it's also possible right now it's charged as a felony, which is the most serious sort of crime. It's possible that the jury could only find him guilty of what is called the lesser included. So that's the misdemeanor charge there. It's a little bit less serious. So it's potentially he could resolve this case with a misdemeanor and would already have that time in jail and just walk out of here.
What do you think the chances of that are, though?
It's unclear. I mean, again, if they just find him to be harassing and annoying witnesses, that's really only rising to the level of a misdemeanor. So it really depends on what the defense attorneys are going to bring out in their case.
I think it is interesting to note that he really said that I don't want you getting involved in this. He's a lawyer himself, so you could argue, I know what it's like for you to be involved in this whole shooting. I don't want you to be involved. I don't want you to have to be called as a witness. Then again, he was the shooter. She was the driver. She was there. It looks worse for him than it looks good for him. And speaking of Tex McIver and the statements that he makes, we had the opportunity to see him provide an interview to the police. That was played in court in the beginning of this trial. I want to play for you right now his police interview, and there's a lot to discuss. Take a look.
Danny was driving, right? Okay.
I was in the backseat.
In the backseat? Okay. And what's the next thing that you can, I know you said you kind of fell asleep there. What's the next thing that you can remember from there?
Despite the fact I was tired, I don't sleep well in cars.
Right.
But we went through an area I felt it was particularly dangerous at night.
That's one that has a particularly high population of homeless people, at least in the daytime. But at night, there's a lot of people there. And I quickly said, this is a big mistake, and we're in a place that we don't belong.
Right.
And I said, I'd like to, if you don't mind, please hand me my gun.
Right.
So Diane reaches in, pulls it out, hands it back to me, and by then we may have been on Piedmont. Anyway, I'm relatively satisfied that we're out of that kind of area.
Right.
And I guess I just laid back again and went to sleep. But she came to a stop, and I was handling the gun. And I realized it was in my lap, and it went off.
What you just heard is the explanation that Tex McIver and his team has been explaining for why Diane McIver was killed that night. That they were all driving in the same car, that there was a group of people that they were nervous about, that they were in a bad neighborhood. He asked Diane to give him his gun. He put it on his lap. He fell asleep, and when he woke up being startled, the gun went off. Yosha, here's the thing. What he said was not discounted by Danny Jo Carter when she testified. She said that's what he said. He said, oh, ladies, I wish you didn't make this turn. And he asked Diane for the gun. But there was a dispute because Danny Jo never saw these bad-looking groups of people.
Exactly. So that is what the prosecution is going to capitalize on. When a defendant makes a statement or talks to the police, that is really the story that they're often locked into. So in this case, the prosecution is going to find any discrepancies, things that he is now mentioning on the stand or the defense is trying to bring out that he didn't mention at this point, which he should have mentioned, which is one of the reasons why a lot of times we don't have criminal defendants ever speak to the police. At this point in the investigation, I believe the lawyers still thought that it was just going to be an accident.
But what's interesting is I'm not seeing anything that says beyond a reasonable doubt that he's guilty of murder yet. I don't see that, especially when Danny Jo Carter relayed the same series of events. Maybe she didn't see the group of people, but she said that's what Tex told them. It's not like he had a gun that he was hiding in his pocket. Diane gave him the gun. It was in a plastic bag in the console. He said that there was a group of people. I wish you didn't go into this neighborhood. What am I not getting? I don't see yet, based upon the totality of the evidence so far in this case, and we're in day 13, that this looks like murder yet.
Again, the prosecution hasn't rested. They still have more evidence to present. I think a lot of what it's going to come down to is the gun in the car. Was there a hair trigger? Was he actually putting a lot of force on that gun? And that would indicate that it would be intentional. So I think there's still a lot of evidence to come out. We're really in the stage right now of the trial where we're trying to understand the motive of why he would have done this.
That's the key word there, motive, 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 motive. That is really what the prosecution is hitting on, the financial motive for why Tex would have shot Diane. And that has really been the summary of this entire week. When we come back from our break in a little bit, we are going to talk all about motive. Now, again, I'm looking at a live feed into the courtroom. As soon as trial starts, we'll make sure to jump into it, but we really have to understand more about this case and what the prosecution and the defense will ultimately do. But before we do, I have to talk about another case that we'll be covering here on Law and Crime Live. It's a case out of Florida. We talked about it a little bit this week. It's been delayed until May. It's the case of Newman Raja. It's an officer-involved shooting. I know it's very unfortunate. We keep hearing them more and more in the news. And this one is out of Florida. We have a short recap about that case. Take a look.
Police Officer Newman Raja faces a hearing to determine whether he can present a stand-your-ground defense to manslaughter and attempted murder charges. He's accused of shooting and killing motorist Corey Jones, who had broken down by the side of the road. Raja was in plain clothes and in an unmarked police car when he pulled up near Jones. He claims Jones pointed a gun at him and that he fired back in self-defense. Prosecutors claim some of the shots came after the victim threw down his gun. Here's how Florida's Stand Your Ground law works. The law eliminates a duty to retreat if a defendant faced an imminent threat of death or great bodily harm, or if the defendant needed to prevent a forcible felony. It applies in a dwelling, residence, or vehicle. In this case, the defense will apply if the motorist posed an imminent threat and if Raja was not the initial aggressor. Florida's Stand Your Ground law changed in 2017. Under the old law, the defendant had to prove Stand Your Ground applied. Under the new law, the prosecution must convince a judge it does not apply. This is Aaron Keller for the Law and Crime Network.
So that hearing, that Stand Your Ground hearing, has been delayed till May. But Yosha, real quick, you saw this case. We've been looking at it. What do you think?
Well, the defense is going to have a really hard time here proving that he was facing imminent death based on the state's what they're saying happened, because they're saying that he didn't identify himself as a police officer. They're saying that even after Mr. Jones tossed down his gun, he used his own gun to continue to shoot him. And that's a very disturbing
There was a break in the gunshots. You hear gunshots, and then there's a break, and then there's 3 more gunshots. Those 3 more gunshots might be really problematic for Mr. Raja.
It definitely would, because if he's shooting an unarmed man, that proves that there wasn't any imminent danger to him, and that really could hurt his case.
What happens if he doesn't win the Stand Your Ground hearing?
It's going to be hard to have a defense, and already...
But it can go to trial.
It can still go to trial, and he's going to have to use a different theory of defense, but this is his best one, which is why his attorneys are pushing so hard here, and ultimately it's going to come down to who has the burden of proof based on that new statute, whether that applies retroactively or not.
And it's in front of a judge, not a jury. It's a little bit of a different situation. So again, ladies and gentlemen, we are keeping a very close eye on the Atlanta courtroom for Claude Tex McIver. As soon as trial starts, we're going to jump right in there. We don't want you to miss anything. But when we come back, we really want to delve into the financial position of Tex McIver at the time he shot and killed Diane McIver. It's a very important factor in this case. We'll take a quick break. We'll be back in a minute. Welcome back to Law and Crime Live, everybody. We are waiting for a live feed in the Claude Tex McIver case out of Atlanta, Georgia. A prominent attorney who is on trial for shooting and killing his wife, Diane McIver. And he is claiming that this was all a tragic accident, that he did not intentionally shoot his wife, that the gun went off by itself. Now, what we're really going to analyze right now as we wait for the live courtroom feed is the motive. The prosecution has set the motive up to be that Tex wanted to kill Diane because of financial reasons. Now, yesterday we saw a lot of testimony about the deteriorating financial position of Mr. McIver. He was not bringing in the kind of money that he was used to. He had a loan out. Diane, his wife, gave him a loan that he kept paying interest payments on. He had to reimburse her for expenses on the ranch. And it became interesting when you look at his finances after her death. There was a cash infusion. He received a lot of money after she died, but that became a back and forth, too, about what he actually did receive and what he didn't receive. Now, at the beginning of this week, there was a full discussion about Diane McIver's will. She had a 2006 will that did not leave the ranch that she shared with her husband to her godson, and that became a big issue. But the other big issue was there a second will, a mysterious second will, that might not have been so good for Mr. McIver, and that the prosecution is kind of implying, did he do something to get rid of it? We have a short recap about this missing will. Take a look.
Prosecutors are trying to convince a jury that Atlanta attorney Tex McIver murdered his CEO wife over money and property. One big question is this: did victim Diane McIver actually change her will? One witness says she was asked to copy a new will, but didn't dare look at it.
Before you made a copy, did you look through the document that you copied?
Absolutely not.
Now, and tell the jury why you didn't look through it.
Well, when Diane said she could only trust me, there was no way I was going to betray her trust. So I would not dare look at anything that she did not want me to be a privilege of.
Another witness said Tex McIver and two other men went through the victim's files.
I know they left the office in a pickup truck. That's the best I know.
Prosecutors seem to want the jury to believe that the victim indeed had a new will, which was never found. Tex McIver's own estate planning attorney had an empty folder for Diane McIver's will, but he said that doesn't necessarily mean a new will was actually prepared. He also said no one tried to hide the document.
Tex never called you up and said, please shred that new will that she signed, right?
No, and if he had, I would have told him to go jump in a lake.
That's right.
Emails between that attorney and the McIvers indicate the couple disagreed about the disposition of the ranch in 2011, but Diane didn't die until 2016. And while Diane McIver talked about writing a new will, there's evidence she never went forward with the plan. Her own attorney testified she never prepared a new will through him, and that it would have been unusual for her to go through someone else. This is Aaron Keller for the Law and Crime Network.
Wills, finances, it can get a bit complicated. So let's try and break it down a little bit. Again, I'm here with criminal defense attorney Yosha Gunasekera. Okay, Diane had a 2006 will. Now, this will was before she had her godson, Austin. So she never updated her will to give Austin the ranch, even though many witnesses have said that was her intention. There's this mysterious second will, which is implied that it might have not looked so good for Tex. It might have left the ranch to Austin. We should all note that when she died, he ultimately got the ranch. But this second will, they had Brian Salters on yesterday, a criminal investigator. He said, I looked through the whole condo. There was no will. You keep saying no one found the will. Why should the jury care about this, Yosha?
The prosecution really hasn't presented a good case for the fact that there is a new will. We hear one witness stating that there may be a new will, but she didn't even look at it. So, and what's really compelling is that Diane's own attorneys are saying, look, if there was a new will, we would have written it, and we didn't write it. So right now, it's really based on speculation, and unless there's someone else, unless there's another witness that they're going to have to say, yes, I saw the new will, it's definitely real, and it was destroyed by Tex, it's just, I don't think they have anything at this point.
So in your opinion, there's nothing indicating that Tex destroyed this mysterious second will that would have left Diane's property to someone else. And two, we don't even know if there was a will, and she could have changed it, but she ultimately didn't. So again, not that much there.
Exactly. There was a lot of conversations about updating the will, but they never got around to it. Just like many people who make intentions to do something financial before they die and then unfortunately don't get to do it. And that appears to be the case here.
And we know that he has a new will. He has a will that leaves a lot of his estate to Austin, Diane's godson, and he even said earlier in the week that this would have been Diane's intention. She wouldn't let me into heaven if I didn't do the right thing. As we talk about the finances, though, what I want to play for you right now is this was a video that was shown in court where Tex McIver gave an interview to the media outlets talking about his financial position in comparison to Diane. Take a look.
God bless, Your Honor.
You may.
Finances?
This is your fault. We were already over.
About the couple's finances does not match reality.
I am worth 2.5 times what her estate is worth.
That's interesting because anybody who was listening yesterday knows that Dean Driscoll, financial expert, took the stand, and Mr. McIver's financial position was not as secure as he just said it was. Take a look.
Category down here at the bottom.
I do. Those are transfers directly from his wife to his accounts, and that those were across all of 6 accounts.
Okay. And these are cash transfers into Mr. McIver's account from his wife.
Correct.
So in 2013, can you tell the jury what is the total amount of cash transfer from Mrs. McIver into Mr. McIver's account?
A little over $180,000.
And then as of September the 26th, 2016, how much cash from Mrs. McIver's account was actually transferred into Mr. McIver's account?
Almost $70,000. And you'll notice that number is almost 25% of the total sources in the first 9 months of 2016.
So in 2016, the total amount of all the cash that went into Mr. McIver's account from all of these different sources totaled how much as of September the 26th, 2016?
$277,177.
It's the number of cash that went into his account.
Correct.
And the percentage of that cash that actually came from his wife, this $69,000, accounts for what percentage of that cash?
It's about 25%. So what this slide does, is this takes the same data that I just showed you, and it shows it to you graphically. Now, someone could critique this and say, well, you're saying that from 2013 to 2016, there's a 69% decrease in the sources of cash. And that would be a little fair because this only deals with 9 months. So what I did is I went back and looked and said, all right, well, if I took this entire year, what would it look like? And it would just go down. It would go down to 59%. Okay. But this does graphically show you the significant decrease of his sources of cash between the last year that Mr. McIver was an equity partner and 2016.
And this graph illustrates that the sources of cash for Mr. McIver from the last year he was an equity partner until the date of Mrs. McIver's death, it seems to decrease every single year.
That's correct.
Okay, so Tex McIver was not 2 times worth the estate of Diane McIver. Yosha, that's bad for multiple reasons. One, the court just caught him on the jury just saw him in a lie, saying that he was worth more than his wife when he wasn't. He was cash poor at the time that she died. And number 2, doesn't that kind of feed into the prosecution's motive? Here's a guy who's not making the kind of money that he was. He was relying on his wife. He was paying her interest payments. And then when she died, he received an inheritance from her. So this isn't looking so good. Yesterday wasn't so good for him, no?
I still feel like it's a flimsy motive. There's a lot that can be said here. First, as people get older, as they reach retirement age, their finances slow down. And often in relationships, one person earns a lot more than the other person. So just to say someone is in a bad financial situation, that's enough for them to kill their spouse or their loved one, I still think that they're missing the mark here.
Well, his inheritance from Diane was worth between $3.6 and $4.6 million. They had a different relationship than other people in the fact that she was loaning him money. She even teased him at one point and said, he was worried about going into debt, and she was comparing him to their ranch, the person that takes care of the ranch, and said, you better look at his job description. That's your future. That's not so nice, but it does kind of give you an indication their relationship was a bit different. And so if he's constantly relying on his wife, and he might have felt better, or the narrative could go, killing her might have made more sense.
But if he's constantly relying on her and constantly borrowing money from her, once she's dead, that cash flow stops. So again, I think there's two sides to every story. She's trying to leave money in her will to her godson, Austin, but Tex is doing the same thing. So I think the prosecution is still missing the mark here as far as motive.
You articulated very well the defense's argument there, and I think that's a strong argument that he was relying on her. But what about the idea that he sold her jewelry, her furs, in the days after she died? Again, we heard Billy Corey, Diane's boss, said, Tex, you should take that and put it in a safe deposit box for Austin later on, but he didn't do that.
Is he husband of the year? Maybe not. But again, to say someone committed murder and to put them in jail based on just initial reactions of how they act after someone died is just not rising to proof beyond a reasonable doubt here.
That becomes the question, doesn't it? And that's really what we're analyzing here today. We are waiting for a live feed. I'm looking at it right now in the Claude Tex McIver case. As soon as trial starts again, we're going to jump right back into it. The judge is having a meeting this morning. That's why there is a delay. It's better than the reason we've had delays in the past, considering a juror has been consistently late. But that's not going on. I see the judge on the bench right now. So possibly after this short commercial break, we can go into court. You don't want to miss anything. It's been a week of motive, trying to understand what happened between Tex and Diane, and it's not an easy question. So we'll be back after this short break. There's a lot to talk about in the Tex McIver case. Stay tuned. We'll be back in a minute. Welcome back to Law&Crime Live, everybody. So that's a live shot right there in the Claude Tex McIver courtroom out of Atlanta, Georgia. That is the judge speaking right there. We believe the trial will start up again today. And Yosha, we're watching this in a week filled with, how shall I say this, the financial motive, really putting it there. I've seen a flavor of a little different motives, though. Have you seen the flavor of trying to say, Diane was a shrewd businesswoman, and she wasn't the nicest person, and she teased people. So I keep seeing the prosecution throwing out a lot of different motives here, that she was bad, not a nice person, the financial aspect. And I think they even did a flavor of Tex might have been two-timing her with the masseuse. I'm curious by your opinion, are they throwing too much out there?
I think they're trying to throw anything out there and see what sticks, because right now, nothing is looking like it's sticking. I mean, even the thing with the masseuse and the rain boots, I mean, apparently those rain boots were for use for anyone who visited the ranch. So it seems that they're putting stuff out there and then just getting discredited again, and it's not looking good for
That's
them.
A very good point. A lot of the witnesses put forward by the state, and remember, the state is still presenting their case. The defense hasn't presented their case yet. A lot of the witnesses, they didn't elicit the testimony that the prosecution was hoping to get out of them. However, that's not the case with every witness. As Yosha said, Jay Grover, who worked with Diane McIver, he provided some very interesting testimony. In particular, he talked about the conversations that he had with Tex McIver after Diane died. Listen very closely, and you be the judge. Is this something suspicious, or is this just a bad husband? Take a look.
So can you tell the jurors, while you were down on that level and you saw Mr. Hickey and Austin and the defendant on his phone, did the defendant say anything to you at that time? Did y'all have a conversation?
Yeah, we kind of we were tossing the football while he was on the phone, and then he apparently finished his call, and he and I kind of gravitated toward one another, and right there while Austin and Jim continued to throw the football, and Tex and I had a conversation.
Okay. And can you tell the jurors, what did he say to you at that time?
He asked me if I knew anything about Social Security and Social Security checks.
And is that all he said to you?
Well, he asked the question, and I kind of made a joke, and I said, well, I know I'm not old enough to collect Social Security yet, and he said, well, I was just wondering about Diane's Social Security, and he went on to say, I was just wondering if I could collect her checks now. And I told him I didn't have any idea. I could find out, but I had no idea whether he could. In fact, I think I went on to say, I guess you can, but I don't know. And he said, well, he would find out.
So that was an interesting trial strategy. I hope many of you caught that. Clint Rucker, who's the DA, right after he got Jay Grover on the stand to say that Tex was asking about whether he could collect Diane's Social Security checks right after she died, he paused. He let the jury marinate on that statement for a minute. But did it really have the impact that he wanted? Yosha, what do you think? Again, he was trying to collect her curious about collecting her Social Security benefits. But then again, his wife died, right? So he doesn't have money coming in. Is it something more nefarious?
The defense is definitely going to try to paint it just as a man who's trying to figure out his financial future. If he really is in the type of money troubles that the prosecution has brought up, he's going to be very worried about his future, and he is going to be looking into what happens next. And I think what's also important to mention is that this testimony is just a snapshot. We don't know what was said before or after he talked about the Social Security. He could have been talking about her death and how sad he was, and then asking about the Social Security.
That's an interesting perspective, but I can tell you what Jay Grover testified to after that. This is a continuation of the statements that Tex made.
Yes, sir.
Okay. Now, having had the opportunity to review your notes, is your memory refreshed about when you would have had this conversation?
Yes, sir.
Could you tell the jury when?
Again, I don't know the exact date, but it was on the Friday of that same week.
Okay. And can you tell the jury the phone conversation, it was actually with the defendant?
Yes, sir, it was.
Can you tell the jury, what did he say?
We had a conversation about a friend of mine purchasing the SUV. The Expedition, the Ford Expedition.
The one that was involved in this incident?
Yes, sir.
And during that conversation, did you learn whether or not the defendant actually had regained custody of the SUV at that time from the police?
Yes, sir.
What did he tell you?
That he had that SUV and that it was hidden at James Hughes' house.
Who was James Hughes?
James Hughes is a friend and many of the people. I mean, myself, Mr. Corey, Tex, Diane. He's a handyman. He works for us. Works for the Corey company part time. He cleans our offices, but he does detailed work on cars.
Okay.
He's a jack of all trades.
Okay. And did the defendant tell you why he had the car hidden down at James Hughes' house?
To keep the press from.
Okay, so that's a little bit different, a little bit more interesting. Trying to sell the car that was involved in the shooting. Yosha, we only have about 20 seconds. That's a bit more meaty.
Yeah, it doesn't look great, and so the defense is going to put on other witnesses that show that he was a compassionate person, that he wasn't just thinking about the bottom line and the money, but yes, trying to hide a key piece of evidence.
The evidence.
Never
he's
really...
trying to, in a way you could say he's trying to hide the crime scene. It all happened in the car.
But it's so stupid because the police are always going to be able to find that car, so it doesn't seem like a very good strategy.
Not his best point in the trial, but again, we are looking at the live courtroom feed. As soon as it starts, we're going to jump into it. You don't want to miss anything. We'll take a quick break. We'll be back in a minute. Welcome back, everybody. We're live right now in the Tex McIver courtroom. Trial has started again. This is the case of a prominent attorney who's on trial for shooting and killing his wife, Diane McIver. Let's listen in.
And who's delivering the evidence goes right up to the window and hands over the evidence into our evidence receiving area to an evidence receiving technician. We can also receive it via U.S. mail or postal service, FedEx, UPS, and then we can also receive it via a lockbox. And the lockbox is a locker that the evidence will be placed in. The door is locked and it can no longer be accessed by anybody outside of the GBI. So the people will go, the evidence technicians will then go retrieve the evidence from this lockbox, and then it will go into a cool storage until it is entered into the crime lab database. An evidence receiving technician will take out the evidence, look at the submission form, enter in the information from that submission form, and it will get a unique identifying case number and barcode, and the barcode is affixed to the evidence. It is then sealed or inside of a plastic bag, and a photograph is taken, and then it awaits an evidence receiving until it comes up to the toxicology section for.
So that's Casey Wilson, a forensic toxicologist who just got on the stand. Before we delve into her testimony, I want to talk to Yosha Gunasekera here. There was an issue at the beginning of trial today. The prosecution wants the jury to be able to pull the trigger of the gun, and the defense objects. They do not want this. The judge will revisit this issue later. I haven't heard about this happening so much, Yosha. What do you make of it?
I believe it would be highly prejudicial for the jury members to be able to actually pull the trigger because we don't know the state of the gun at the time this incident occurred. Also, interestingly, we're really making the jurors experts if they're allowed to pull the trigger. We don't know what kind of gun experience that they have, so they're going to form their own conclusions based on pulling that trigger, and really they should only base their conclusions on the evidence that's actually presented in court.
And let's not forget, we don't know what mode the gun was set in, and there's a difference between dual action and single action. One requires more pounds of pressure to pull the trigger than the other, so I don't think it would be fair to just let the jury pull the trigger.
Exactly. We can't recreate what happened that night because there's two different versions of what happened that night. One is that it was a hair trigger, and then the other was that he put a lot of force on that gun to shoot Diane. So it would be, as of now, it would be very unfair for them to do this.
All right, let's see what happens. We're going to delve right back into the live courtroom feed.
Number that's assigned for that submission. For this one, the DOFS case number is 2016-10-28446, and the toxicology section received item 6.
And item 6, where does it go after it gets its unique case number? What's the next step for it?
It is moved from the evidence receiving area up to our toxicology section, and it's placed in cool storage there as well, and only accessible by other toxicologists or trained staff.
And what is the testing that was done with the sample that you received from Yosha McIver?
I performed the blood alcohol postmortem testing.
As a result of your testing and eventually your conclusions, did you generate a report?
I did.
Right. I'm going to show you what has been marked and shown to defense counsel as State's Exhibit 308. So look at that for me. Do you recognize State's 308?
Yes, ma'am.
All right. How do you recognize that?
It is a copy of the official report that has my signature on it.
And is 308 a true and accurate copy of the report that you authored?
Yes.
Appear to have any changes or deletions on it?
It does not appear to be.
Your Honor, I'm going to tender state 308.
Mr. Harvey, the usual, it's in the record. Yes. No objection to that. All right. It's admitted into the record.
You told the jury about the testing that's about to happen on the samples that came in from the Fulton County ME's office. Tell the jurors, give them an idea of how the testing works for what you're about to do.
Okay. Once I'm assigned to the case, I will take the specimens and I will sample it twice. And then I will place it on a headspace gas chromatograph with a flame ionization detector. Sorry, headspace gas chromatograph, flame ionization detector, mass spectrometer.
What is that?
That's basically the instrumentation we use. We will gently heat the specimen to release the alcohol.
Again, that's Casey Wilson, a forensics toxicologist, probably going to be on the stand to talk about, Yosha, you correct me, probably maybe the blood alcohol content that was in Diane McIver and also Tex McIver in the night of the shooting. Remember, they had been drinking, and that becomes a big issue in this case. When you mix alcohol and a loaded weapon, Yosha, it's never a good mix, am I right?
It's never a good mix, and it could really play to either side here. The defense is likely going to argue that that reduced his intent, that he was partially sleeping, that he was a little bit drunk, and this was all just an unfortunate accident. So it's going to be interesting to see how the prosecution spins it.
Right. It's an interesting perspective also because we can't forget, we have to talk about this. Diane McIver, the victim in this case, before she died, she told hospital officials it was an accident. So it's rare that you get that statement from the victim, but I wonder if they are going to, the prosecution at least, try to say, look, she was so intoxicated, maybe it's not fair to say what she thought was an accident really wasn't.
Exactly. That's likely how it's going to come in for the prosecution. There's already been mention that they were drinking at the restaurant that they were at, and they're also sometimes they have drinks on the road. There was a bottle of wine, I believe, in the car that night. And so they're going to say that her mental capacity was impaired not only because she was drinking, but obviously because she had been fatally shot.
And Tex McIver himself was drinking, and he has this sleep disorder, or at least this alleged sleep disorder that the defense keeps bringing about. I wonder if it's exacerbated by being quite inebriated, being so tired that he fell asleep and wasn't quite himself when he woke up. Is that some avenue you think the defense will explore?
Definitely. They're going to try to explore everything. And a lot of this testimony sometimes seems a little tedious, but it's very important for all the witnesses to be able to say what they need to say, because when the evidence is closed, the prosecution can't say, oh, oops, we want to recall someone, or
right,
we forgot to mention this. It's too late. So they're really trying to be very thorough here and cover all their bases. And they might not even close on everything here, but just to have it in their arsenal is going to be very important.
Well, we don't want you to miss anything, so let's listen in live to the trial testimony.
Valid test, as you just described.
It was.
As a result of that, were you able to determine a blood alcohol content for the sample that you had?
Yes, I did.
And tell the jury, what was it?
Ethyl alcohol result by gas chromatography was 0.108 plus or minus 0.005 grams per 100 milliliters, and that's 100 milliliters of blood. 108 grams per 100 milliliters.
Just so the jury has a little bit of context about that number, tell the jurors what is the legal limit, or sort of the per se amount here in Georgia?
The per se level for Georgia for an over the age of 21 driver is 0.08 grams per 100 milliliters.
And what is this number sort of in relation to that, in a way that might be helpful for them to understand?
It's approximately 1.4 times higher than the per se level.
Let's tell the jurors just generally, as a result of your training and experience, are you familiar generally with what the substance alcohol does to the body?
Yes, ma'am.
And tell the jurors about that.
Alcohol is a CNS depressant, meaning that it's going to...
what depressant?
A CNS, or central nervous system depressant. And what that means is it's going to slow the information processing from the brain to your spinal cord and to your nerves and your muscles. So it's going to slow everything down. Basically, alcohol is dose dependent, so the more alcohol you have, the more central nervous system depression that you have.
As a result of this central nervous system depression, are you able to observe any other characteristics that come from consuming alcohol? What kinds of things are observable as a result of consuming alcohol?
Depending on the level.
This may be very, very formulaic and procedural, but alcohol messes you up. I mean, this is basically the bottom line. It affects your mental capacity in certain different ways, but that's what really Casey Wilson, the forensic toxicologist, is on the stand to talk about that. We'll jump back into her testimony in a minute. I do want to, again, bring up this issue with Yosha Gunasekera about this gun, because at the beginning of the day there was a conversation between the attorneys and the judge about whether or not the jury will be allowed to fire the gun. I pulled the trigger of the gun, I should say. And Bob Bianchi, who is an analyst here on Law and Crime, said that he's seen this happen, but that's a rare thing. He really doesn't think that the prosecution should do it. It's risky. And he even said, look what happened with O.J. Simpson and the gloves. Yosha, do you agree?
I completely agree. I think what they can do is they can look at the gun, they can handle the gun, but pulling the trigger of the gun is going one step too far, and it really could be grounds for a very strong appeal in this case, especially because it's done so rarely.
So rarely. All right, let's listen again back into the live trial testimony. Again, you're watching the Claude Tex McIver case, a prominent attorney who is on trial for murdering his wife by shooting her from the back seat of a moving car. He is claiming that this was all a tragic accident and that he didn't mean to fire the gun. A forensic toxicologist is on the stand. Let's listen in live.
It stops drinking. Basically, you have an absorption phase, which I like to use the ladder of a slide to take into account the number of drinks that you have. The number of drinks is how high you're going to go on the slide. Then you're going to do a peak time of before you will start the elimination process. So the peak is where you're sitting on top of the slide, and then the elimination part is where you're going to slide down the slide. So your body is getting rid of the alcohol during that slide down to go back to zero.
And is it possible to have your sort of peak time after your last drink?
Yes.
So it's possible to be on the way up after you stop consuming alcohol?
It depends on the stomach conditions. If you are on an empty stomach condition, you're going to absorb the alcohol in approximately about 30 minutes. If you have a slight amount of food in your system, you're going to have, it'll probably delay the peak up to about an hour. And if it's even a heavy meal, then it would be even up to 2 hours. Your peak would be delayed.
Is there anything about the type of alcohol that affects the numbers we've been talking about, whether it's wine, liquor, beer? It means if, depending on what you're drinking and the percentage of alcohol that is in the substance that you're drinking is what's going to affect the numbers. So you may have to have more cans, the volume will be different. So you may have to have more cans of beer to equal, 2 glasses of wine to equal, 2 shots of liquor. And does the size and the dependency or the familiarity of a particular person with alcohol affect the number?
The familiarity with drinking does not necessarily affect the number. The only part that it does affect is the elimination.
All right, let's break this down. Again, Casey Wilson, a GBI state crime from the State Crime Lab Toxicology, is there on the stand. Yosha, we know Diane McIver's blood alcohol level came back at 0.108. What does that tell you?
So in most states, the legal limit to drive is 0.08. So we're seeing just slightly over the legal limit to drive. Again, it's not a level where she would be out of her mind or confused or really impaired, just impaired enough to be able to drive a vehicle.
For anybody viewing, this is a photo of the actual crime scene. It's all in a car, and that's where the gunshot, the trajectory of the bullet came through. I'm very curious to hear about that because it looks like from that angle that it would be sitting on his lap, that he didn't point it directly above her in a way that would look like an intentional shooting, Yosha.
It's going to be interesting because you're going to hear two totally contradictory accounts. The prosecution is going to say that it was raised, and the defense is going to dispute that.
Exactly. All right, everybody. So we are going to have to take a quick commercial break, but don't worry. We're going to go straight back into the courtroom. We don't want you to miss anything about this case. There's so many different factors. We'll be back in a minute. Welcome back to Law and Crime Live, everybody. That's a live shot into the Tex McIver courtroom, a case that we've been following closely about a man who's charged with shooting and killing his wife. And now, right now on the stand is Casey Wilson, a forensic toxicologist. She is under cross-examination by the defense attorney, Bruce Harvey. Let's listen in live.
Correct?
Correct.
Okay. So, and you can refer to that whenever you like. On 9/28 of 2016, right, was when your division received blood?
We received it on 9/29.
9/29?
Yes, 2016.
All right, 9/29. And you received that blood from the medical examiner's office?
Correct.
The medical examiner's office had already performed the autopsy and had drawn blood and preserved that blood to send to you, correct? That's what you understood?
That is my understanding, yes.
And when you got it in your division, does it go into a refrigerator? Does it go into some particular place where it is preserved?
Yes, we do put it in cool storage, the blood specimens, as soon as they are received at the lab.
And does it come in little vials like test tubes?
They do, with stoppers.
Like purple top stoppers or other type stoppers with any preservative in it?
They do.
Okay. And that's to preserve the content of the whatever substance might be in there, correct?
It's to preserve the life of the specimen.
Okay, so this witness is under cross-examination. I want to ask Yosha right now, what is he trying to get at here? Because what she testified under direct examination was that Diane McIver's blood alcohol level came back at 0.10. She talked about the effects of alcohol on the brain. What is he trying to do here?
He's trying to establish what we would call a chain of custody. He's trying to see if the blood was tainted in any way from when it came from Diane's body to when it came to the lab where it was analyzed by her. And it's really what every prudent defense attorney can do, because if there's some doubt that if the blood was heated, for example, or cooled too much, then the blood alcohol could be completely erroneous.
But what does it even matter in the sense that even if there was a problem, and he establishes that there was a problem in the chain of custody, and even if the blood was tainted, why does it really matter what her blood alcohol content was?
It matters because the prosecution right now is going to argue that at a 0.10 she was impaired. And because she was impaired when she said it was an accident, she really didn't know what she was saying, for example. So if we can say actually she wasn't impaired, her blood alcohol content was likely much lower or has to be discredited entirely, that really strengthens the case that the defense has.
Yeah, that's a good point, especially when the victim herself has provided a statement about what happened in the car. Let's listen in live.
The height and weight of the individual?
Yes, those are important.
Okay, so what information did you have about the height and weight of the individual?
I did not have any information as to the height and weight of the individual.
Okay, but that's, let's see, height and weight affect ultimately the way alcohol is absorbed in the body, correct?
Height and weight would affect how many drinks that you would need to consume to get to this alcohol level.
Okay. That's one factor that is included. Those are two factors, actually, that are included, correct? Height and weight is something that you need to know how alcohol affects a particular person?
Height and weight is how much or what you would need to actually use to calculate the number of drinks somebody would have consumed to get to this level.
Okay. You also told us about stomach contents of food, correct?
Correct.
And particularly, perhaps, the type of meal, right?
Yes.
Whether it was, for example, a salad or a steak, right? With baked potatoes, with some bread, with some dessert, that makes a difference too, right?
The types of foods could affect the calculation of how much somebody would need to have to get to a certain peak alcohol concentration, yes.
That's exactly what you were telling us before, right?
Yes.
Right. The time, also, the time when the drinks, both the time of the ingestion of the alcohol and
Casey Wilson, still on the stand, a forensic toxicologist. Yosha, the way blood is tested is a little bit different than other ways of testing, correct?
Yes, it is, and blood is actually a lot less common. Usually when you're trying to ascertain how much someone has been drinking, you do a breathalyzer test. And so with blood, there's a lot more variables here. And again, focusing on how the sample was handled is very important, and also focusing even on when it was taken from Diane. Alcohol breaks down in bodies over time. And so that's, again, something that the defense can use to cast doubt on how good the sample is.
How often, and what is happening under cross-examination, is you see this, what, as you said earlier, trying to show that the samples were tainted, that it wasn't handled properly. How much does that actually work in a trial, establishing that?
I think it's important here because I think the defense has to go after every little thing.
Does it work, though? Do they actually show that a lot of times in trials?
Do they show that?
Do they show that there was an improper handling of evidence?
Yes, it's something that you should always do. That's why the person who actually handled the evidence has to testify. There's something called a confrontation clause issue where the person who is testifying has to face the defendant and has to be under questioning. And it's something done in almost every case.
Yeah, and you can't deny the evidence in this case. Again, we're looking at the blood alcohol content right now of Diane McIver. What was in her system the night of the shooting? And did that affect her ability to say certain things, including when she told medical professionals this was all an accident? We keep discussing this. So when we come back from this break, we're going to jump right back into the courtroom. We don't want you to miss anything. Each testimony is important. We'll take a quick break, and we'll be right back. Stay tuned.
You have any information as to whether this particular person...
For shooting and killing his wife, Diane McIver, and he's claiming that it was all a tragic accident. On the stand right now is Casey Wilson. She's from the GBI State Crime Toxicology Lab. Now, the reason she's important, she's talking about the blood alcohol content of Diane McIver, the victim in this case, and the night in question. How much did she have to drink? How much was in her system? And the reason that's important, for many different reasons, but one of the key reasons, is because when Diane McIver went to the hospital after she was shot, she had a conversation. She said some words to the attending physicians and some of the medical personnel. Now, if her ability to speak and what she was actually processing was impaired, that is going to call into question some of the statements she made. I want to play for you right now the testimony of Dr. Suzanne Hardy, the attending physician the night of the shooting. Take a look.
I would have said about the same, but I have no specific recollection. I mean, I would guess between 4 to 6 nurses and techs around me. There was at least one other doctor, if not 2 at the time, helping me. Scribe still in the corner.
Okay. So I'm clear, when you say techs, that's T-E-C-H-S.
Technician.
Technician,
Yes.
not techs as in the defendant in this case. He was not in it.
Correct. No, he was not.
Okay.
So we've got several technicians, we got nurses. So what is going on? How is the activity in the room at that time?
It was I mean, it was pretty controlled. Everyone has their own job.
Right. To an observer standing outside of the room, does it kind of look like a controlled ballet, or is it scrambled? What does it look like?
I mean, we joke it's a controlled chaos.
Right. How about noise in the room? Is it particularly noisy?
Not particular so that I remember.
Okay. And so when Diane McIver began to speak, you were able to hear her based on where you were positioned.
Correct.
Okay. And if you need to refer to the medical records, I'll just put them here for you. They've been marked and entered the evidence in States 241.
Thank you.
Okay. Can you tell the jurors, did you say something to Diane McIver when she began to speak, or did she just speak on her own?
She probably spoke on her own. I don't remember specifics of what she said to make me start asking her questions.
Okay. But you do remember asking her questions?
Yes.
Can you tell the jurors what question did you ask Diane McIver?
Once you know it's a trauma, you kind of go down a pathway. So the first question is just any medical history, and then any surgical history. I don't know if I asked for allergies or not, but that's one of the next ones we ask about. And then I guess at the same time, then we were rolling her, so we were trying to determine any more of her wounds. So that's when I saw the other gunshot wound on her back and asked her, did you hear a gun? Or I asked her where the gun was held. And she said, I was holding it behind my back. Do you want me to continue with this?
Hold on one second.
Okay.
The question you asked was what?
Where was the gun held? In a trauma, you cannot determine the exit or entrance wounds. And so just by asking that question, you could determine where the entrance was.
Okay. Because you were trying to find out where the bullet went in?
Yes.
Okay. And her response was what?
I was holding it behind my back.
Okay, so that's an important point. Did you hear what Diane said to Dr. Suzanne Hardy? I was holding the gun behind my back. Now, the reason that's important is because today we are looking at the toxicology report. We're trying to understand how much blood, how much alcohol was in Diane McIver's system. And if she had so much that she couldn't comprehend what was actually happening, saying that I was holding the gun when really it was Tex holding the gun, it shows a bit of confusion. And the reason that's important is because the defense is really pressing upon the point that Diane McIver said repeatedly that it was an accident, But if she was so inebriated, did she maybe wrong it wasn't an accident? Let's hear a little bit more of the testimony from Dr. Suzanne Hardy about this confusion.
What did you ask her next?
I don't think I asked a follow-up question right then.
Okay. And so this conversation with Diane McIver, can you tell the jurors, you were looking at her?
Yes.
Were you close to her?
Yes.
And you were trying to get information so that you could better take care of her?
Yes.
And when you rolled her over on her side, you could see the other wound to her back?
Yes.
And can you tell the jurors kind of what was the state of her medical condition at this time?
She seemed just sleepy to me, tired, somnolent. Most of the time I remember her eyes closed, just talking in a quiet voice.
Okay. And when she was responding to your questions, can you tell the jurors, was she yelling or screaming, or was it like a whisper? You tell us how loudly she was speaking.
It seemed quiet, but enough that I was right by her head that I could understand and hear her.
Okay. And you have no doubt in your mind that these are the things that went on between yourself and Diane McIver?
That's the truth as I know it.
Okay. Now, can you tell the jurors at a certain point, did her condition start to worsen?
Worsen in terms of?
Strike that and ask you a better question.
Okay.
Was there a time when Diane McIver said other things to you after this?
That's when she said it was an accident.
Okay. And tell the jurors this. Was that in response to a question that you asked her?
No.
And when she said it was an accident, can you give the jurors some context about how long did she say that after the last question that you had asked her? About how many shots did you hear? And she said one. How much time goes by before she just says it was an accident?
I don't remember specifics, but I feel like it was a pause. So I don't know if it was 30 seconds, a minute, and then she said it.
Again, the question becomes, was Diane McIver in the right state of mind when she made the comments that she did to medical professionals? Well, you're looking at a live feed of the courtroom right now. There was an expert on the stand talking about the blood alcohol content of Diane McIver that night, and what we showed you was the testimony of Dr. Suzanne Hardy talking about what Diane said. So again, I'm here with Yosha Gunasekera. They're in a sidebar right now in the court. We'll jump back into it when it goes live, when the audio comes back. But Yosha, what do you make of that? Was Diane in her right state of mind when she made these comments?
Well, they're certainly trying to do everything they can to discredit her statement that it was an accident. They're trying to say that, you know, the alcohol played a factor. Obviously, she was shot very severely. But the testimony to me sounds that she said something. She said that she had the gun behind her back, and then it was actually Tex. It sounded like she misspoke and then immediately clarified her statement. So there's nothing that I'm hearing at this point that sounds like, you know, she was delirious by any means.
Right. Her words weren't garbled. It wasn't like she couldn't form sentences saying that I had the gun or he had the gun. I don't know if it's that much of a difference. I mean, her blood alcohol content, again, it was 0.108, Yosha. Not that terrible, correct?
Yes, it's not. Again, alcohol really depends on the person, but this is not levels. This is not double the legal limit. It is over the legal limit. Again, for driving, it's not over the legal limit for just being able to have a cognizant conversation.
Right, and Bruce Harvey, who was the defense attorney for Tex McIver, got this witness to admit that can a person who drinks socially on a regular basis still engage in normal behavior, such as walking and talking? And he said yes, with practice, yes. And we know that they were social drinkers. So we're going to go to a quick break. When we come back, we're going to go right back into the courtroom, and we don't want you to miss anything. And this case has really been exciting, and we can't wait to keep showing it to you. We'll take a quick break. We'll be right back. Stay tuned. Welcome back to Law and Crime Live, everybody. You're watching a live feed into the Claude Tex McIver case. This is a case about a man who's charged with shooting and killing his wife, and he is saying that it was all a tragic accident. We saw earlier the testimony of a forensic toxicologist talking about how much blood alcohol content the victim had. Now on the stand is Sarah Peppers. She was just introduced. Let's listen in live to hear what she is going to testify to.
What exactly does your job entail?
One of my primary duties is to analyze evidence for the absence or presence of gunshot primer residue.
And what exactly is a microanalyst? Your job?
A microanalyst is what we typically refer to as the scientist in the trace evidence section. We are typically dealing with evidence that cannot be seen by the unaided eye and that can be transferred between people or between people and objects or between objects.
And can you please tell us a little bit about your background, education, and training to become a microanalyst for the GCAP?
Yes. I earned a Bachelor of Science in Biology with a minor in Chemistry from Clayton State University in May 2009. Upon being
So as Sarah Peppers, she's a DNA analyst on the stand going over her background. Let's analyze a little bit more about the gun. Yosha, why does it matter about the gunshot residue? We know who fired the gun, and we know that it was fired through a plastic bag. Why does this matter?
Well, believe it or not, even though it's conceded that Tex did shoot the gun, the prosecutor still has to prove every element of the crime. So they actually still have to prove that it was Tex who shot the gun, even though it's not contested. They have to do that legally.
We should let our viewers know that there was a stipulation made during the break. Again, as we're trying to analyze what happened that night, we're trying to understand what was in Diane McIver's system. She did not have any drugs or methamphetamines in her system. She just was drinking. She had some food because they were coming back from dinner. Yosha, in the break, we actually talked about the fact that Mr. McIver's a lawyer. If he is convicted, he'll be disbarred. But what happens if he's not convicted? What would still happen to his law license? Could he go back to practicing?
He could still face consequences by the American Bar Association if they think that his conduct is unbecoming of the professional standards that lawyers must ascribe themselves to. So it's not just that you're convicted of a crime and you lose your license. If you're, if you're lying or you're doing other forms of conduct that are unbecoming of an attorney, you could be sanctioned. You could lose your license for a period of time, or you could be disbarred if the actions are serious enough.
Yeah. Let's listen in live to Sarah Peppers again. She's analyzing DNA in this case, and we can hear what she has to say.
Exhibits 387, 388, and 458.
I'm sorry, Ms. Griffin, could you give me those numbers again, please?
States exhibits 387, 388, and 458.
And 387 is which? Oh, you got to identify them.
Yes. I'm going to show you States exhibit number 387. Do you recognize that?
Yes, I do.
And what is that item?
This item is a silk package that was identified as containing a brown holster.
Okay. And I'm going to show you States exhibit number 388. Do you recognize that?
Yes, I do.
And what is that item?
This item is a package containing a plastic bag.
And I'm going to show you States exhibit number 458. Do you recognize this item?
Yes, I do.
And what is item 458?
These are stubs that I actually created in the laboratory as part of my examination for gunshot primer residue analysis on the plastic bag.
And with regards to States exhibit number 387, how do you recognize this item?
Again, that's Sarah Peppers, a DNA expert, just authenticating certain items into evidence right now. We're going to be going into the conversation about the gun. Again, I'm here with criminal defense attorney Yosha Gunasekera. I know we don't have that much time left, Yosha, but I do want to talk about this gun. What is pivotal for the prosecution to prove in relation to this gun?
So first, again, they have to prove that he shot the gun, which doesn't seem to make much sense since everyone's already conceding that. But first, they have to prove that he shot the gun, and then they have to prove that he shot the gun intentionally, that this was not an accident.
And the whole thing that we talked about when the defense in their opening statement said this was single action or double action, depending upon the pounds of pressure used. And we know at the beginning of the day there was a whole conversation about whether or not the jury can fire the gun, can pull the trigger themselves. If they can establish what mode it was set in, is that a game over for the prosecution?
No, it's not a game over because the defense is going to rebut that. They're going to. Every side there's going to be two sides here, and they're both going to contradict each other. Both sides are going to put on ballistics experts that say, yes, it was a hair trigger, or no, it wasn't a hair trigger. So it's not necessarily dispositive. It's what happens when the jury believes who is more credible. They have to make the decision.
We're talking about reasonable doubt, and really that's what the defense has to show here. I'm going to ask you real quick, we have a little under a minute here. The idea that a man who wanted to kill his wife could have done it in a lot of different ways, but shooting her in a public place with another person in the car, does that make sense to you?
No, it doesn't, and I see loads of reasonable doubt. And this is the prosecution trying to put their best forward and present all their evidence, and I don't think that they've met this incredibly high standard. And then we're going to see the defense present a case that is going to be very strong as well. So I would be shocked if Tex is convicted in this case.
Real quick, you think they put him on the stand?
I don't think so.
Yeah,
I
they
think
don't
that
need
there's
to.
I think that there's enough reasonable doubt without him, and he has had very contradictory stories, so it's probably best that he does not testify.
Yosha Gunasekera, thank you so much for joining us. We can't wait to have you back on.
It was great to be here. Thank you.
All right, everybody. So we are going to go to a quick commercial break, but when we come back, we're going right into the courtroom. Stay tuned. We'll be right back.